Thank you for joining us today. In an era where the lines between privacy and security are constantly being tested, it is crucial that we, as a society, examine the actions of those tasked with safeguarding our nation. Surveillance is a powerful tool, essential in protecting us from threats both foreign and domestic. However, it is also a tool that must be wielded with the utmost care, guided by legal frameworks, ethical principles, and a deep respect for the rights of every individual. Today we want to discuss a significant issue that originally came to light in 2017, the unlawful access of personal data by New Zealand's intelligence agencies. This situation underscores the ethical challenges faced by agencies like the New Zealand Security Intelligence Service, NZSIS, to accessing personal data. Specifically, we will explore why it is crucial to adhere to privacy laws and maintain transparency in these operations. The implications of this unauthorized access are far-reaching. It raises significant concerns about the protection of individual privacy, the transparency of governmental actions, and the delicate balance between national security and personal freedoms. When agencies entrusted with safeguarding our nation disregard the laws meant to protect us, they not only compromise individual rights, but also erode public trust in essential institutions. Today we will delve into the ethical and legal dimensions of this issue. We will examine the breaches of the Privacy Act 2020, which mandates that personal data be collected and handled with transparency, consent, and security. We'll explore how the NZSIS's actions contravene these principles and why it is imperative that intelligence agencies' operations adhere strictly to legal and ethical standards. We will also consider the broader implications for information governance, including the role of algorithms in data processing and the risks associated with their misuse. As technology evolves, so too must our frameworks for managing privacy and security. The aim of this discussion is not merely to critique, but to seek solutions. How can we ensure that intelligence agencies operate within a framework that upholds both national security and individual privacy? And what steps can be taken to restore public confidence and prevent future breaches? In 2017, it was revealed that the NZSIS had accessed a vast database containing the personal information of a large number of New Zealand citizens without the necessary legal warrants or oversight. This discovery was made by the Inspector General of Intelligence and Security, who found that these agencies had breached both legal and ethical standards. This unauthorized access raises serious concerns about privacy and the protection of individuals' personal data. When government agencies, especially those tasked with safeguarding national security, fail to follow the law, it undermines public trust and opens the door to potential misuse of power. The lack of proper internal controls within these agencies is a critical factor in the situation. It highlights the need for stricter oversight mechanisms and a more transparent approach to how intelligence operations are conducted. Citizens have the right to know that their data is being handled with utmost care and legality. The ethical concerns: 1. Privacy violations, 2. Lack of transparency, and 3. Balancing security and privacy. The legal concerns: Privacy Act 2020. The New Zealand Privacy Act 2020 mandates that data be collected in a fair and reasonable manner and for a lawful purpose. The NZSIS case violates the following principles. Data must be collected for a specific lawful purpose, Principle 1. Transparency is indispensable, Principles 2 and 3. Data acquisition necessitates consent or authorization by law, Principle 4. Security is a fundamental principle that mandates that secure storage and protection of data, Principle 5. Principles 6 and 8 grant individuals the right to access their data and rectify any inaccuracies discovered. Data should not be disclosed without appropriate authorization, Principle 11. Privacy Act Principles 1, 2, 3, 4, 5, 6, 8, and 11 have been breached by SIS as individuals' information was collected without a clear and lawful purpose, Principle 1, without their consent or knowledge, Principle 2, They were not informed how it would be collected, Principle 3. The manner of collection was unauthorized, Principle 4. They did not know if it was being stored safely, Principle 5. They were not permitted access to their data, Principle 6. The accuracy of data could not be ensured, and disclosure of data was moved freely between Customs New Zealand and the NZSIS, Principles 8 and 11. The New Zealand Algorithm Charter. Additionally, automated processing of data in New Zealand should be conducted in line with the Algorithm Charter, of which NZSIS does not appear to be a signatory. Not following the rules in the Algorithm Charter says that automated data processing is not being properly supervised and managed. The Charter pushes for justice, openness, and responsibility in the process of automating decision-making. If these principles aren't followed, results could be unfair or biased, which could lead to more privacy violations and less trust in intelligence agencies among the public. American case law, the balance between privacy and security. On May 7, 2015, the United States Court of Appeals for the Second Circuit ruled that the National Security Agency's bulk collection of Americans' phone records was illegal, as the law allows them to collect information relevant to counterterrorism investigations and not to collect bulk data on US citizens' phone records without a reasonable connection to a counterterrorism investigation.
We now turn to the ethical evaluation and recommendations for this case. Starting with the issue of data privacy and unauthorized access. The issue of unauthorized access to personal data is a fundamental ethical concern. The NZIS was not authorized to access travellers' personal data at that time, and they acted outside the law. Their primary argument for doing so was that they were an intelligence and security agency, and so were subject to an exemption under Section 57 of the then Privacy Act 1993. It is important that national intelligence agencies are able to gather sufficient information, as we'll discuss shortly. In this case, the NZSIS's access to passenger records without proper authorization violated individual privacy rights. Laws and international standards like the GDPR and the New Zealand Privacy Act both protect data in ways that are directly at odds with unauthorized access to that data. For example, the GDPR says that collecting data must be legal, fair, and clear, and that people must be told about how their data is being collected and used. The then Privacy Act 1993 exempts intelligence and security agencies from following some of the principles, but they're still bound by the other principles, including individuals' rights to access their personal information and correct it under Principle 6, and individuals' rights to expect that information collected for one purpose, in this case by customs, monitoring lawfulness of travel, not be used for any other purpose under Principle 10. Our recommendation: data was accessed without permission or the right legal authority, which violates people's basic privacy rights. The NZSIS breach shows that these standards were not followed, and our team recommends that government agencies should always comply with the law. Our next issue is around lack of transparency. This is because the public loses trust in intelligence agencies when those agencies ignore requests for data details and delay responses to lawful information requests. The GDPR guarantees individuals a right of access to knowledge of the logic involved in automated decision-making. The lack of transparency in NZSIS's actions, in contradiction of the GDPR's requirement for a right of access and understanding the logic involved in data processing, further illustrates the breach of fundamental privacy rights by not informing individuals about the collection of their customs data so as to effectively prevent them from exercising their right to access this information. Effective transparency practices would necessitate transparent communication regarding data collection, processing, and the logic employed in automated decisions, thereby enabling individuals to comprehend and contest the utilisation of their data. Our recommendation: government agencies like NZSIS should be more transparent with individuals, explaining what data is being collected and how it is being used, which will not only improve public trust, but also the usability of the various systems they rely on. Impacted individuals are a broad category, and complicated explanations might not be necessary if NZIS are able to show their system to be sufficiently reliable. The final issue we're going to explore here is balancing security and privacy. While certain data may be accessed for security operations, this must be balanced against the ethical obligation to respect and protect individuals' privacy. The NZSIS claim that they require surveillance networks to maintain protection of New Zealanders from violent extremism, espionage, foreign interference, and international and domestic terrorism. And it would be difficult to argue against the need for such protection, or the fact that it's a societal good. Capewell and Lilford in 2016 claimed that paternalistic government interventions, such as mass surveillance, encourage a healthy and safe society and are an appropriate response to the seriousness of the threat. On the other hand, Trackman, Walters and Zeller in 2020 argue that consent is still a key component of the trust between an individual and their government. They make the ethically attractive case that meaningful consent is a balancing act between an individual's right to choose what happens to their data and a robust regulatory framework. In the NZSIS case, specific authorizations and legal frameworks were in place to restrict data access to the extent required for security operations. These were not followed. Our recommendation. In the face of such disregard for the law, it could be argued that only in the event of an evident imminent threat should immediate data access be permissible, and only under strict conditions. It is possible to preserve this equilibrium by strengthening the legal framework for authorizations and building non-compliance consequences into it. This framework could require specific authorization from other government agencies before accessing data, ensuring that the balance between national security and individual privacy is maintained. On the other hand, if someone is obviously setting out to harm society, like a would-be political assassinator climbing to a roof with a sniper scope, immediate action can be taken for data access. The NZSIS claim they aim to be as open as possible about their work, while ensuring there's no risk of compromise to national security. The use of travellers' data without their knowledge or consent is a considerable breach of trust, but not necessarily of national security. When weighing issues of national security, individuals have a moral right to transparency and explanation. When this is demonstrably not possible, be provided with evidence of the reliability of the NZSIS systems. We turn now to the next part of our evaluation, information governance risks. The risk of prioritising individual rights over national security is that significant threats such as terrorism may overwhelm our nation. The risk of prioritising national security over individual rights is that our nation may become a nanny state, ever more restrictive of the free choices of its own citizens. We also make a note here on the risks of algorithms. Algorithms are often only as good as the data they're trained upon. Tainted data sets will lead to errors in an algorithm, undermining its reliability. In other cases, the data might not be tainted, but might be reflecting a bias. An example of this is policing algorithms, which can reflect biases inherent in the actual police statistics. The NZIS have not been transparent with us about the use of the algorithms that they trained on travellers' data. However, the predictive policing model provides a cautionary lesson for us in bias in the use of screening algorithms. Turning now to legal principles. 1. Unlawful access to a database containing personal information without obtaining legal warrants or consent, thus violating privacy laws. 2. Breach of legal procedures, where there was a failure to follow established legal protocols for data access, which raises questions about compliance with national laws designed to protect citizens' rights. 3. The potential for legal liability. Unlawful actions should, expose the agency to legal challenges and undermine the integrity of the legal framework governing surveillance in New Zealand. Turning to certainty and gaps in our thinking. Data practices are clear, predictable, and legal when there is certainty in the ethical and legal standards. The case against NZSIS shows significant gaps, which lead to new concerns. We've got lack of clear legal frameworks. The NZSIS did not have clear legal power, which led to widespread, unauthorised access to personal information. This lack of clarity led to many breaches of privacy. We have insufficient control. There wasn't enough accountability and control, so their illegal activities could go on without being stopped. We've got poor handling of ethical concerns. The NZSIS's unwillingness to deal with problems of openness and consent made people even less trusting. We've got bias in algorithms, because we know that if you don't keep an eye on automated data processing, it can introduce or make biases worse, which can lead to unfair discrimination or targeting. We've also got advances in technology. As technologies like AI and machine learning get better, laws and morals need to be updated to deal with new privacy and security issues.
In light of the ethical and legal complexities surrounding the NZSIS case, the most ethically preferable course of action is to prioritise strict adherence to privacy laws. This means ensuring that any data access is fully authorised and transparent. Intelligence agencies must strike a balance between national security and respect for individual privacy. Before accessing personal data, explicit legal authorization should be obtained along with a clear justification, especially when dealing with sensitive information like travel records. To further address ethical concerns not explicitly covered by legislation, it is advisable to establish an internal oversight mechanism within the NZSIS. This could include proactive legal reviews, an ethical assessment panel, and continuous monitoring and reporting, ensuring that all intelligence activities comply with legal, ethical, and procedural standards. The decision to prioritise strict adherence to privacy laws is deeply rooted in the fundamental principles of the rule of law and privacy rights. Privacy laws like the New Zealand Privacy Act are specifically designed to protect individuals from unauthorised surveillance. By following these laws, the NZSIS will not only meet legal standards but also uphold its moral obligation to respect individual privacy. This choice is not just about legal compliance, it's about doing what is right for the people by safeguarding their privacy. The reasoning is straightforward. When agencies operate within a clear legal framework, they avoid overreach, prevent abuses of power, and maintain public trust. Furthermore, the Intelligence and Security Act of 2017, in particular Section 92, mandates that any data access or interception must be proportionate to the threat being addressed. This raises an ethical challenge in determining what actions are truly proportionate. For instance, from a relativist perspective, monitoring a community's communications may be justified by societal values prioritizing security, while others might see it as excessive. On the other hand, subjectivism emphasizes the beliefs of the individual decision-maker. What one officer sees as proportionate due to their focus on security, another might view as unjustified due to their emphasis on privacy. Additionally, the Act provides essential oversight mechanisms, such as the role of the Inspector General of Intelligence and Security, to ensure the NZSIS actions remain both lawful and considerate of individuals' rights, thereby preserving public trust. To effectively communicate this approach to diverse stakeholders, transparency and accountability are key. For the general public, it is essential to convey that while intelligence operations are crucial, they must never come at the expense of privacy. This message can be reinforced through public statements, reports, and regular updates on how data is managed and protected. Government bodies should emphasize the importance of collaboration, ensuring that all intelligence activities are legally compliant and ethically sound. Additionally, it is crucial to engage with those impacted, providing clear explanations and channels for redress which will make them feel heard and valued. Reflecting on this case, the most concerning component is the extensive unauthorized access and lack of control. It is eye-opening to see how quickly privacy can be compromised when proper safeguards are not in place. This raises concerns regarding the future usage of developing technologies such as artificial intelligence and big data. If the framework for protecting sensitive information needs to be regularly updated and strictly enforced, we may face similar or even more severe breaches. This case is a crucial reminder that privacy and security are not mutually exclusive and must be given equal priority. As new laws or technological advancements emerge, it is essential to re-evaluate our approach to guarantee that privacy rights are safeguarded without sacrificing security. On the other hand, we can view security and privacy as complementary rather than competing rights, as security is a prerequisite to a free, open, and democratic society. When security is strong and well managed, it creates a stable foundation where privacy can be protected, enabling individuals to live freely and exercise their rights without undue interference. I will pause there for any questions. Thank you for your time.